Hello, my name is Chris Baer with Castle Wealth Group. I'm a certified elder law attorney and practicing financial advisor, and I'm very excited to spend the next 40 minutes or so talking about death, taxes, and incapacity. Who's excited? Raise your hand. I can't see you even if you did raise your hand, but if you did, I appreciate that. This is important stuff. It's planning for what happens if you pass away and planning for what happens if you don't. So we're going to spend the next 40 minutes or so really diving deep into estate planning, creating your own rule book versus relying on the government's rule book. And we're going to talk about some of the threats that could affect you once you do set up that rule book. What are the things that we need to plan for? And then we'll close and create an action plan moving forward. And if you want to see how this information applies to your situation, what we'll do is we'll set up a short 15-minute phone call, learn a little bit about where you're at, figure out where you want to go, see if we can help you, and then we can set up the next step, which would be to have a strategy visit where we really dive deep into where you're at, review whatever estate planning documents you have, if any, and figure out if they are good or if there's any gaps, and then we look at ways to close those gaps. We have offices throughout Michigan, as well as a virtual process where we can work with our clients via Zoom in a virtual environment similar to this. So with that, let's go ahead and get started, and give me a minute as I share my screen. I hit this button and I hit this button and then I hit this button and then we hit this button, and now we are good. So now you should be seeing my screen. It says legal, financial, and tax planning for the second half of life. And like I said, our agenda, talk a little bit about our firm, our team, and how we're structured to help you meet your goals. Then discover the 3 steps plan, protect yourself, including creating that rule book, and then close and create an action plan moving forward. A little bit about me. This is my family. It's my wife, Rochelle, my son, Ryan, my daughter, Madison. And then you see, I've circled it, my son, Ryan, he went through this phase about 4 years ago that no matter what the weather was like outside, he wanted to wear a suit and tie. So it'd be 95 degrees, he'd be playing in the sandbox, and he'd want to wear a suit and tie. So we captured that phase, took a picture, and when we saw the picture, we're like, this is the best lawyer headshot you're ever going to see in your life. Now he's 10 and he's outgrown this at this point. I'm lucky if he's wearing matching socks. A little more relevant, we founded the firm in 2005. We do legal, financial, and tax planning all under one roof. I am a certified elder law attorney, which is the gold standard for estate planning and elder law, and we do help our clients manage their investments as well. I'm an adjunct professor of law. We have a radio show, written a couple books on long-term care, on financial planning. And our radio show, big believers in education. It's called the Chris Baer Show every Sunday at 1 o'clock, where we talk legal, financial, and tax planning for the second half of life. And then it's turned into a podcast. And then also we have this weekly webinar where if you go to www.wisdomwebinar.com, every Wednesday at 1 o'clock, I basically just log in and answer people's questions. There's no script to it. It's a way to just provide education, whatever legal, financial, tax questions you have. You can actually just go to wisdomwebinar.com and sign up for notifications, and you can watch previous episodes actually on our YouTube channel. We have a very large YouTube channel. If you just Google Castle Wealth Group YouTube, you can probably find us. And again, we do legal, financial, and tax planning, and we break that really into 5 key areas that we think everyone needs to plan for. Income planning, that's your retirement planning, managing investments, tax planning. And I think this is one of the biggest risks and biggest opportunities right now is just managing taxes. And with all the current changes in tax laws, there's a window of opportunity that's available. And then, of course, healthcare planning. And I think this is a big risk, especially when we're talking about long-term care. And then legacy planning, planning for what happens when we pass away, creating our own rule book, creating that estate plan, maybe involving wills, trusts. And this is really what we're going to focus on tonight. So, or today, really focusing almost on the back end of things. And then understand that we're all going to pass away, so we need to create that rule book. We're heavily involved in the community. Probably the thing we support the most is Alzheimer's Association. It's something that's near and dear to my heart, as well as many of our clients. So what's the goal? Identify if your current plan meets your goals. So figure out where you're at, figure out where you need to go. Maybe you don't have any plan at all. Well, knock on wood, you made it this far, but now's the time to think about putting together that estate plan. Understand what it takes to protect you and your stuff and your family, both financially as well as legally, and show you how to get what's missing. So at the end of the day, are you all set? Do you have your ducks in a row? And we like to break this complicated area into 3 easy steps. And the first step is to understand the rules, understand the government has a set of rules for you, understand the threats, what are the things that can throw that plan off, and then know your options moving forward. And understand the government has a set of rules for you, and it's your choice of whether you want to follow the government's rule book or do you want to create your own rule book. And the government has a set of rules for you while you're alive. That's called living probate. And that's where if you haven't set up your own rule book, like financial powers of attorneys, medical powers of attorney, you get a knock in your head, someone needs to make decisions with regards to your care, then they're going to have to go to court and create a guardianship. And a guardianship is where someone petitions the court to now make decisions with regards to your care. And if you happen to have money, not only do they need to become your guardian, but also they have to be the conservator. Either way, it's going to be the judge who's in control of your affairs. So most people are familiar with death probate, but they're surprised by this concept of living probate. So how do you avoid living probate? By having what we call disability documents. The big thing is that financial power of attorney to take care of the guardianships and the medical power of attorney. And we'll talk more about these to make decisions with regards to your care. Now let's talk about death probate. Most people want to avoid probate upon death because of it's costly. 3 to 5% of any assets typically get eaten up in costs. Also, it's takes a lot of time. So at the very least in Michigan, it takes 3 months to go through the probate process. And then it's also public. Anyone can see what's going through probate. So how do we avoid probate? Well, upon death, by understanding how estate administration works. So first we have joint ownership. So joint ownership is great for a married couple, but I would not recommend naming anyone else joint to your accounts. Because if you do name like a son or daughter joint to your bank account and they get a divorce, lawsuit, creditor action, bankruptcy, then that money could be lost. And I want you to be taken care of. I don't want to see that money going anywhere else. And then second, we have beneficiary designations. And beneficiary designations are basically a pillowcase of money approach, which could be a problem if you have young children, minor children, or even young adults, 18 to 25. Because I'm young enough to remember if I were to inherit 5,000, 50,000, or 500 when I was going to school, I would have been the coolest kid on campus, but that might have been my only year on campus, right? So most people don't want to rely on that outright distribution, not just because of the poor financial mismanagement, but also what happens if a child gets a divorce after inheriting this money? Where might half that money go? Or what happens if that child passes away? Where might all that money go? It might go to an in-law versus going down to your potential grandchildren. So that's where a lot of people look to trusts as a way to pass assets, because with a trust, you can leave things to your children or beneficiaries in such a way so that whatever they inherit, they have the opportunity to protect it from creditors. So they could be the trustee, they could decide how it's invested, they could receive all the income, but as long as they choose to keep it inside of the trust, it's protected from creditors, it's protected from divorces. And if you were to pass away, the money stays in the bloodline. Now, not all trusts do this. A lot of trusts say it goes all right to the kids at 25, 30, 35. All you're doing is launching a pillowcase of money at those beneficiaries. But if you set up the trust in the right way, where you build in what we call separate share trusts or legacy inheritance trust, then this money could be protected. But if an asset doesn't pass through joint ownership beneficiary designation trust, then it ends up going into probate. And most people want to avoid probate because, again, 3 to 5% of any assets going through probate get eaten up in costs. Also, it's time consuming. It takes at least 5 months to go through the probate process, and it's public. Now, what's the one thing that I didn't mention? A will, right? What about a last will and testament? Well, all the will does is gives instructions to the probate court. So if you want to avoid probate, don't rely upon a will. That's a big myth that a will avoids probate court. It does not. What the will does is gives instructions to the probate court. So if you're relying on a will-based estate plan, understand you're probably sending your loved one to probate court. And again, if you want to avoid probate, which is most people's at least baseline goal with probate, then please give our office a call at 844-885-4200 or reach out to us to book that 15-minute phone call to figure out if we can help you or not. Because again, we don't want to see things going into probate. Now, we've talked about some of the important tools when you have a comprehensive estate plan. Things like a trust, and there's different types of trusts, but think of a trust kind of like a suitcase. You put things into the suitcase, you avoid probate, the stuff goes where it's supposed to go. And then even if you have a trust, you still have a pour over will. So the pour over will gives instructions to the probate court on how to administer your estate. If there are any assets that end up in probate, the pour over will knock those into the trust. And then we have that financial power of attorney, that document that appoints someone to make financial decisions, as well as a medical power of attorney who makes medical decisions for you. Personal care plan is a document that gives instructions to your financial and medical power of attorney on how best to care for you. And then we have a deed. So if you own any real estate, we're either going to do what's called a ladybird deed, which is a type of deed to say it's in your name upon while you're alive, and then upon death goes to whoever you list as a beneficiary. Or we might do a deed directly to the trust if we're setting up an asset protection trust. And then we think it's important to cover any final expenses. I'm not saying rush out and prepay a funeral at a funeral home, but there's different strategies to set aside funds so that your kids or loved ones aren't having to pay those final expenses. It could be paid out of your estate immediately versus waiting on death certificates and everything that goes along with that. So now that we've talked about the documents and the tools, understand not all tools are created equal, right? If I asked you to hand me a paintbrush, you'd have to know, am I painting a wall or am I painting a little figurine to know what type of paintbrush to hand me? Similarly with documents, especially financial powers of attorney. A lot of the financial powers of attorney that we review are only like 3 to 5 pages, and they're what we call blank checks. They're not specific enough. And if you try to take one of these poorly drafted powers of attorney to a bank, then most likely it's going to be missing what we call expanded powers, and they're going to run it through their legal department, and they're going to say, no, I'm sorry, you can't do what you're trying to do. Versus our financial power of attorney, it's about 20 pages. And it's not because we get paid by the word or we like killing trees. It's because we found that we need to include all of the specific language in the documents. So that's one area where you see a big difference when it comes to just general estate planning attorneys or attorneys versus certified elder law attorneys. As a certified elder law attorney, which is a CELA, and there's only about 17 of us, I think, in the state of Michigan, 500 across the whole nation. It's really the gold standard as it relates to estate planning and elder law. And if estate planning is planning for what happens if you die, elder law is planning for what happens if you don't and you continue to age and face all the issues that go along with aging. So the CELA designation is really the gold standard because we have to sit down and take a 6-hour exam. I think only 15% of the attorneys that take this exam actually pass it. And there's over 20,000 attorneys just in the state of Michigan, but there's only 17 of us. So that's where you see a difference in these documents, because these tools, you might have a tool created by a basic estate planning attorney, but they might not have been created by a CELA. And then we have different types of trusts. So what type of trust do you have? And we'll get more into this, but there are different types of trusts. And most people are just familiar with that basic revocable trust that avoids probate and controls the distribution upon death. Both of those things are very important, but there's more than just basic revocable trust. There's also what's called a castle trust. And the way a castle trust works is that it avoids probate, which is important, controls the distribution upon death, but now builds in asset protection, meaning any assets that we move into the trust immediately are protected from creditors and lawsuits. But then also, and this is why a lot of our clients like these, also what the castle trust does that the revocable living trust does not, is that it protects against the devastating cost of long-term care. Now, we haven't talked much about long-term care, and you might not be expecting to have a discussion about long-term care when you're talking about estate planning, but understand that we can address the long-term care question, not just from a financial or investment standpoint, but also from a legal standpoint as well. By creating a rule book or a trust that avoids probate, controls the distribution, and protects against long-term care costs. Now you might be asking, well, how does it protect against long-term care? Well, by us moving assets into the trust, which you can manage, and then making it 5 years before we need a nursing home, then 100% of what we moved into that castle trust is protected from that nursing home or Medicaid spend down. Now, we haven't talked about Medicaid yet, but Medicaid is a governmental program that will help pay for nursing home care. But to qualify for Medicaid, a single individual can only have $2,000 worth of assets. A married couple, they're going to make you cut your assets in half, but at most you can have $120,000 of countable assets. And countable assets are everything other than a home, small cash value of life insurance, personal belongings, prepaid funeral. Everything else is a countable asset. So by us moving assets into the castle trust and then making it 5 years before we need a nursing home, 100% of what we put into that castle trust is protected from that nursing home or Medicaid spend out. Now, what does that mean? That means that if we were to have a stroke and need nursing home care, then we can have governmental benefits pay that base level of care, and then a pot of resources available to pay for additional services to improve our quality of life. Or if we're a married couple and one spouse needs long-term care, that healthy spouse isn't completely impoverished having to pay for that care. Very powerful stuff, especially when you take into account that 1 out of every 2 individuals will need nursing home care. 3 out of 4 will need some form of long-term care. The average stay in a nursing home is 2.5 years, and the average cost of a nursing home is $8 to $12 or $13, $14,000 a month. So the question is, how are you going to go about paying for that? And that's why a lot of people look to Medicaid as a way to help pay for that. But to qualify for Medicaid, you need to qualify. And that's where the Castle Trust comes into play, which is very different than that basic revocable trust. And this is something that certified elder law attorneys really focus on, because estate planning attorneys are just focused on what happens if you die. Certified elder law attorneys are focused on not just what happens if you die, but also what happens if you continue to live and face all the issues that go along with living. And then the other thing to think about is, how are you leaving assets to the next generation? A lot of times, even if you do have a trust, it's just the pillowcase of money approach, where you're saying, okay, I'm launching a pillowcase of money at my beneficiaries at age 25, 30, or 35. Well, what happens if your child gets divorced at 36? Half of that money is gone. What happens if your child passes away at 36? All that money goes to a spouse versus going down to your grandchildren. So instead, that's where a lot of times we're building in this opportunity for a lifetime of asset protection. So whatever your kids inherit from you could be protected in trust for their lifetime. And then if they pass away, then that money can go down to the grandchildren versus going to the in-law, right? The in-laws, we typically call them the outlaws. So we don't want the money going to the in-laws. Instead, we want the money held for your bloodline. And again, that's by setting up in a castle trust or living trust, separate share trust instead of this outright pillowcase of money approach that we see too often. So now that we know all about creating our own rule book, now we're going to talk about some of the big threats that we have. The big threats being the government, long-term care costs, lack of comprehensive planning, lawsuits, and surprisingly, or maybe not surprisingly, your family. Now let's talk about the government. We talked about the guardianships, we talked about the conservatorships. How do you avoid that? By having the financial and medical power of attorney. How do we avoid probate upon death? Understanding that estate administration. We're going to talk about taxes, and we're going to talk about taxes in 3 different respects. We're going to talk about the estate tax, the gift tax, and then income taxes. And again, with taxes, I think this is the biggest risk and biggest opportunity facing families these days, especially retirees. You have some amazing planning opportunities if you take advantage of them. So first, let's talk about the estate tax. Well, the estate tax, otherwise known as the death tax or the inheritance tax, it's a tax, or it's another tax where the government takes another swipe of your assets after you've passed away. But they're nice enough to give us a coupon or exemption, meaning as long as we pass away with less than $11 million, we owe zero in estate taxes. If you have more than $11 million and you're single, you might be taxed at roughly 40%. Now, if you're married, you can double that amount. And with inflation, now it's $23 million for a married couple. However, and this is where some of the planning opportunities lie, there's a law called the Tax Cuts and Jobs Act that runs from 2018 to 2025 that raises that estate tax limit to that $11 million limit. However, in 2025, if it's not repealed further or earlier, that estate tax exemption is dropping from 11 million down to 5 million. And again, if you're married, adjusted for inflation, you can double it. It's about 11 million for a married couple. So that's the way the law is. So if it's at 11 million now and dropping to 5 million in 2025, and you're above this $5 million limit, there's some things we should do to take advantage of this larger estate tax exemption that we have now. Now, there's been a proposal to lower it even further. So right now we're at 11, it's scheduled to drop to 5, but there's a proposal to lower it to 3.5 million. So if you're single with more than $3.5 million, please give us a call to talk about some estate tax planning strategies. Or if you're married and you have more than 7 million, or what we see a lot is with the markets, our clients' assets have been going like this as the estate tax exemption is coming down. So we're going to have an estate tax issue, if not now, in the future. But there's certain strategies that you need to take advantage now due to the Tax Cuts and Jobs Act that expires in 2025 to put your family in the best position possible. So you're not leaving 45%, 55 or 65% to the government if it's over that estate tax exemption with some of these proposals. So that's estate taxes. Now we're going to talk about gift taxes. And the way the gift tax works is you can give $15,000 to as many people as you want gift tax free. But what happens if you give over $15,000? Then you have to fill out a gift tax form to notify the IRS that you're cutting into your lifetime gift tax exclusion amount, which is tied to the estate tax. So the only way that you would pay gift taxes is if you gift over $11 million currently during your lifetime. Otherwise, you just fill out a gift tax form, notify the IRS, you're cutting into your exemption, and then you're okay. So we don't have to worry about gifts for gift tax purposes, but we do have to for Medicaid purposes. Like I mentioned, Medicaid will pay for the cost of nursing home care, but to qualify for Medicaid, a single individual can only have $2,000, a married couple, $120, and then Medicaid looks back 5 years to see if you moved any money around, if you've made any gifts. And if you have, they're going to penalize you. And there is no annual exclusion amount for Medicaid gifting. You gift $10,000, they're going to call that a divestment, they'll penalize you. So what you can gift for gift tax purposes, you cannot for Medicaid purposes. Now, the third type of tax is income tax. And this is one that's going to affect everyone. And again, with the Tax Cuts and Jobs Act, we have a unique planning opportunity where we know taxes are going up in the future. And a lot of people think they might have to go much higher because we're approaching $30 trillion in debt. And if you have pre-tax dollars, IRAs, 401ks, 403bs, 457s, if you have any pre-tax dollars that have not been taxed, understand that one of the most important things that you can do for your family, as well as what you leave as a legacy, is to develop a tax plan. This has been something we've been working with our clients since 2016 when we saw the federal deficit continuing to rise. We were waving the red flag to say, hey, if you have a lot of money in these pre-tax accounts, you have to come up with a tax planning strategy. And then the Tax Cuts and Jobs Act of 2018 happened that lowered marginal tax rates across the board, where if you're at 25%, it drops down to 22% for your marginal tax rate. If you're at 28, it drops down to 24, but then in 2025, it's going right back up. So we know unless things change, we have these artificially low tax brackets. So it's an opportune time to reposition money from a tax deferred 401k or IRA to some type of tax-free account, whether it's a Roth IRA, cash value of life insurance, 529s, health savings accounts. But developing a tax plan is one of the best things that you can be doing now because we know taxes are going up. And if you aren't having annual reviews, looking at your tax return, you're really missing some big opportunities. And that's something that we can certainly help you with if you haven't been looking or aggressively planning for higher taxes in the future. Like I said, this is one of the biggest opportunities that's available, and it's a huge risk, and there's a limited time to plan for this, thanks to the Tax Cuts and Jobs Act and some of the law changes and proposals that we've been seeing. And again, think of it like this: you look at your pre-tax IRA, you see 377,000 sitting there, but is that all your money? No, you still owe money to the IRS. It's kind of like a mortgage. You have the silent partner in the IRS, and if they raise their taxes, if income taxes go up, the value of this account drops. So if taxes go up 3 to 4%, which they're scheduled to in 2025, if not sooner, then the value of your account, because you're going to owe more tax, drops. So again, let's look at this intelligently, just run the numbers. For example, here's a very simple way to understand this. You have this 22% tax bracket. So the way taxes work is first you fill up the 10%, then the 12%, and then you fill up the 22. So a portion of your money is taxed at 10%. Even Bill Gates, a portion of Bill Gates's money is taxed at 10%. A portion is then taxed at 12%. And then you have this bucket. And if you're a married couple, let's say you have $100,000 worth of income, that's going to put you in the 22% tax bracket. But here's the thing, you have room in that 22% tax bracket to get up to about 170,000 before you jump into the next higher tax bracket. So what we could do is we could move 70,000 from your IRA, pay the tax, and now we could do a Roth conversion, or there's a whole slew of different things that we could do. Typically what we do when we're doing tax planning is first figure out how much to move and then where to move it. And a Roth is a good option, but it's not always the best option. There's other options there. So if you're not looking at filling up your that 22% tax bracket, if you're in the 22% tax bracket, you're missing out, because what's going to happen? Your 22% tax bracket right now, when the Tax Cuts and Jobs Act ends, is going to 25%. So we know that that's how the laws currently are right now. So I would not only fill up the 22% tax bracket, but also explore filling up the 24% tax bracket. Or I have clients that are filling up all the tax brackets now because taxes, this 37 marginal tax bracket, it's been as high as 60%. So a lot of people think taxes have to go up more than just the 3 to 4% of the Tax Cuts and Jobs Act. A lot of people think taxes might go up a lot more. And if you look at this tax train coming down the tracks, let's remove money from the train tracks, pull money out of the IRAs, 401ks, pay the tax, and do something else with it. Get out of that partnership with the IRS. And again, this is one of the biggest risks and biggest opportunities based on the current laws. And then throwing on, also we have the Secure Act that just passed in 2020 that says that if you leave pre-tax money to the next generation, they're going to have to pay all the taxes within 10 years, and their chances are they're going to be at higher tax bracket. So again, if you want to have this tax planning conversation, please make sure to schedule that phone call with us. And then one of the things that we'll do if we do decide to kind of dive deeper is we'll take a look at your tax return and develop a tax plan moving forward. Because really, we have a different approach. You might have someone doing your tax preparation. That's really looking at taxes through a micro lens of how can we minimize taxes in one specific year. And I had a client come in, over $3 million of investable assets, and their CPA had worked really hard to get them down into the 12% tax bracket for the previous year before we started working together. They were a couple years away from when they had to take their required minimum distributions, and with all their pre-tax IRAs, I showed that they were going to be in at least the 22% tax bracket for the rest of their retirement. And so what we did is we looked at taxes through a macro lens of not just trying to minimize taxes in a specific year, but minimize taxes over a lifetime. And not only a lifetime, but also what you leave as a legacy, what you leave as that next generation. And so we were able to put together a tax plan to make much of the rest of their retirement much more tax efficient, where they might actually be in the 0% tax bracket. And guess what? If taxes go up, if taxes double, what's 2 times 0? Still 0. Guess what? This also affects their Medicare premiums moving forward. Their Medicare premiums are the absolute lowest they can be. And guess what? Also, your Social Security, whether it's taxed or not depends on your income and your RMDs. Guess what? The rest of their retirement, their Social Security will not be taxed. So that's the difference between looking at taxes through a micro lens versus a macro lens. And again, this is something that we can help you do. We help clients put together legal, financial, and tax plans. And we can help you with a piece of the puzzle, or we can help you with a whole puzzle. Now, as if taxes were not depressing enough, we're going to talk about long-term care. And this is a recent article about a Nobel Prize winning physicist who had to auction off his Nobel Prize for $765,000 to pay his medical bills. And when you read the article, the medical bills were nursing home costs. So this is what we see. We see the elder care continuum of people starting off living at home with no functional limits. And then as they begin to age, they need more and more help. And so we start off living at home and then we bring in assistance. And that assistance might take the form of a spouse, children, or private duty home care. And if we start paying for care, especially at home, you're looking at maybe $1,000 to $3,000 per month. If you're buying a couple hours per day, couple times per week. Then we might move into independent or assisted living, and the lines here are starting to gray, but you're probably looking at about $2,000 to $5,000 a month. And then if you're looking at assisted living with memory care, you're probably looking at about $5,000 to $8,000 a month. And then if you're looking at nursing home care, you're looking at probably $8,000 to $12,000, $13,000, $14,000 per month. And the average stay in a nursing home is about 2.5 years. Okay. And we know that 1 in 2 individuals will need nursing home care, and 3 out of 4 will need some form of long-term care. And so this is one of the big concerns, is how do we pay for the devastating cost of long-term care? Because we're living longer than ever. Well, this is where we have 2 approaches. We can either plan ahead, where we can look at strategies like the Castle Trust. We can look at what's called asset-based long-term care, or we can do what we call crisis planning. Where if you do have a loved one in a nursing home right now, there's things we can do at the last minute to try to protect some of their assets. And it's messy. It's more difficult to do crisis planning. Pre-planning, if we set things up right, we could protect 100% of your assets. At the best, if you have a loved one in a nursing home right now, there's things we can do at the last moment to maybe protect 50% of the assets. And understand, at the end of the day, we have 6 ways to pay for long-term care. We can private pay, we can have the kids pay, we can look at long-term care insurance, Medicare, veterans benefits, and Medicaid. So we have these 6 ways to pay for long-term care. And let's first start talking about private pay. So private pay is just paying out of your own funds. So you have money, you saved it, your nest egg, and now we just spend it down. The second option is we can have the kids pay. Now, a lot of times they don't pay financially, but they pay in terms of their time. Whether they're taking time out of their day to visit the certified elder law attorney, or they're putting their life on hold to become a full-time caregiver. So typically we don't want to rely on that. Third way is long-term care insurance. And there's 2 types of long-term care insurance. There's pure traditional long-term care insurance, which I'm not a big fan of. The reason I'm not a big fan of that pure traditional, you just keep paying on it long-term care insurance is, A, you might pay for it your whole life and then you never use it and all that money is wasted. Or B, you might pay for it and then 20 years down the line, they increase your premiums where now it's not affordable anymore. So I had a client, they came in, they had a policy they've been paying on for 20 years, paying about $4,000 a year for this policy. Well, then they increased the premium on them from $4,000 to $10,000 a year. And they're retired at this point. So the question is, how are they going to go about kind of fixing their budget to now pay for this? And so they're only left with a couple of options. They could let the policy lapse. They could take a reduction in benefits or pay a higher premium, which is difficult when you're on a fixed budget in retirement. So for those reasons, I'm not a big fan of traditional long-term care insurance. It never really have been. But instead, now we have a new way of approaching this called asset-based long-term care. And with asset-based long-term care, we chip off a portion of your assets, let's say $300,000. And now that $300,000 is turned into $600,000 of long-term care money, or if you pass away, could be $600,000 of death benefit tax-free to your loved ones. So it's a way to chip off a portion of your assets. And we know you're either going to need long-term care, or you're going to pass away, or some combination of both. So if you're to use $200,000 of that for long-term care, that would be $400,000 of a tax-free death benefit. And there's no ongoing premiums with this. It's just kind of reallocating where our funds are located. So that's a way that we look at asset-based or traditional long-term care insurance. We look at it not through the form of pure traditional long-term care insurance, which has those two big problems, but instead we look at asset-based long-term care. Now, the fourth way to pay for long-term care is Medicare. Now, Medicare does not actually pay for long-term care. What it does is it pays for short-term rehab. So if you fall, you break your hip, you go into the hospital, you're admitted for 3 days, then you're discharged to a nursing home, 1 to 20 days will be paid by Medicare. And then 21 to 100, you're going to have a copay unless Medicare picks that up. That copay is about $176 per day. And that's why most people have a Medicare supplement plan to cover that 21 to 100 day period. But after 100 days, Medicare runs out. So we can't rely on Medicare as a long-term care payer. Fifth, we have the VA benefit. And the VA benefit's a great way to pay for home care or assisted living because it can pay up to $1,000 to $2,000 a month for veterans, surviving spouses, but it's a drop in the bucket when it gets to nursing home care, which is at $8,000 to $12,000 a month bill. And that's where sixth, we have Medicaid. Now, Medicaid's really only going to pay nursing home care. It's not going to pay for assisted living. Really, it's not going to pay for home care. But what it will do is help pay for that devastating $8,000 to $12,000 a month nursing home bill. And like I said, Medicaid has an asset test where a single individual can only have $2,000 worth of countable assets, and a married couple, they make you cut your assets in half, and at most you can have $120,000 of countable assets. And Medicaid looks back 5 years to see if you moved any money around, and if you have, they're going to penalize you. And again, that's where the Castle Trust comes into play to help protect those assets. So now that we have an understanding of long-term care, let's move into the next threat: lawsuits. So people are always getting sued. That's why this woman is still on TV. That's Judge Judy. If you don't know, she's really well paid. Her contract details came out recently, but she's still on TV. So that tells me people are still getting sued, and divorces, creditors, bankruptcies are happening. How can you protect your loved ones? By, instead of leaving it outright to them, leave it to them in separate share trust. How can you protect yourself? Instead of a revocable trust, maybe set up an asset protection trust like the Castle Trust. Okay. Now, lack of comprehensive planning. This is something we see in our office all the time. We put these 5 areas together. So legacy plan, income planning, investment planning, tax planning, healthcare planning. And we call this all together a retirement and legacy blueprint. We put together a full blueprint for our clients. We can help you with a piece of the puzzle. If you just want us to look at that will and trust, that's great too. But we do have the ability, and our team has the ability to help you in all of these different areas. And too often we see things are mismatched where the legal plan doesn't match up with the tax plan or the investment plan. And one of the things that we can really do is bring this all together in a fiduciary way, where we owe you attorney-client privilege. No matter what we're talking to you about, we always have to work in your best interest. Unfortunately, there's a lot of financial professionals out there where that's not the same. Now we're going to meet some crazy family members. And the first person we're going to meet is Elaine. And Elaine is your husband's next wife. In the months since your death, has brought home-cooked meals to your husband 6 times. Each time she visits, she wears a skimpier outfit. She can't wait to redecorate your home, especially that hideous wallpaper you chose. And she thinks there's no good reason that money earmarked for your children shouldn't be spent on more important things like jewelry, sports cars, and European spa vacations. So the question is, how would Elaine get your money? Well, let's say you're married. We have husband and wife. Husband passes away, everything goes to wife. Or let me rephrase that. Husband and wife passes away, everything goes to husband. Husband grieves for a month, meets Elaine, they fall in love. They get married, husband passes away. Everything now goes where? Does it go to the kids? No, it probably goes to Elaine. Like if you're married right now, ask yourself, if I pass, where do my assets go? It goes to the spouse. So how do we protect against the Elaines of the world? By setting up a trust that maybe provides for Elaine, but upon death, the assets don't go to the Elaines of the world, they go to your beneficiaries. And this also could be Biff the pool boy, so it goes either way. Now, let's meet another family member. This is your son-in-law, Fred. Hasn't had a job since '99, belongs to a religion you consider a cult, sells t-shirts at concerts by a band called Fish, and you think he's fond of chemical substances, and he thinks it's great that he has rich in-laws. So let's say you and your spouse pass away. and you have one of these revocable trusts that say outright to my daughter at 25, 30, 35. Well, what happens if your daughter or Fred divorces your daughter at 36? Where's all your half the money going to go? To Fred. What happens if your daughter dies at 36? Where's all the money going? All the money is going to Fred. So instead, what we can say is upon death, we can leave things to our daughter in trust, and she could be the trustee of it, decide how it's invested. But whatever she leaves in trust would be protected from the divorces, protected from the creditors, and the money would stay in the bloodline without going to the Freds of the world. Okay. Very different than that beneficiary designations, very different than that outright at 25, 30, 35. So now that we've talked about the threats, we talked about the rules, let's understand our options. First, we want to stay in control. So we don't want to become a burden on our loved ones. So we want control. We don't want to become a burden, and we want to try to keep things as simple as possible. Now, we talk about some very complicated tools, but our goal is to make it as simple as possible. And my goal is for you to understand the difference between documents, just a set of tools, versus true planning. This is what we focus on as planning. We focus on first figuring out what is your goal, then helping you develop a strategy to plan for your goal, and then to figure out which tools or documents to utilize. We want you to understand the costs and how to minimize them and choose the right plan for you, not the right plan for us or the right plan for that financial planner who's not acting as a true fiduciary, but is just acting in a best interest or suitability standard. As an attorney and true fiduciary, we always have to act in your best interest. So it's the plan that is right for you and no one else. Now, a lot of times with that rule book, that's estate plan, that's kind of the starting point. That legal entity is the foundation of any plan, because we never know when life's going to throw you a curveball. So you need to create your own rule book. And we have revocable trusts that avoid probate and control the distribution upon death. And then we also have castle trusts, which avoid probate, control the distribution upon death, but build in that asset protection. A little more on the castle trust. You're in control during your lifetime. You have access to the income. The principal can be accessed at any time, and you can even pass this asset protection to the kids, protecting against nursing home, long-term care, probate, lawsuits, divorces, bankruptcies, and even trustee problems. So let's look at a couple just examples of how we might put this planning together. And understand, it's not just about a trust. Also, we do the will, the financial power of attorney, the medical power of attorney, et cetera. But let's just take Patty and Tim. Let's say Patty's frightened by the idea of Tim needing long-term care. They're not a fan of traditional long-term care for the reasons I said, and they think taxes are going up in the future. So like a lot of my clients, they walk in just kind of following that old style of defer, defer, defer until you retire, and hopefully taxes will be lower in retirement. And we find out a lot of times they're the same, if not higher. Again, majority of my clients fall in that 22% tax bracket. They might be in the 24% while they're working on the high end, or the low end is 24, but still they're in the 22%, somewhere in there where they need about $100,000 worth of income in retirement. And that puts you in the 22% tax bracket. So that myth that we're going to be in a lower tax bracket upon retirement, a lot of people don't really see that because they've saved so much, and now they have to start taking out RMDs and everything. So they have $1 million pre-tax, concerned about long-term care. What might we do? Well, over the next couple of years, we pull out some money out of the IRA each year. So pay the taxes at a lower rate now, and we move that money into a castle trust, and we can invest it in whatever you want, whether it's XYZ mutual fund that was in your IRA. We could do the same XYZ mutual fund inside of the trust, but now it's protected from the devastating cost of long-term care. Because as soon as we move money into that trust, what it does is it starts a 5-year race, where if we can make it 5 years from the time we fund the trust before we need a nursing home, then everything inside of the trust is protected from that nursing home or Medicaid spend down. So now if we needed $8,000 to $12,000 a month worth of nursing home care, that would be covered by Medicaid, and we'd have $750,000 of asset protected money. And also we've paid tax and saved in terms of overall taxes over that time period, given where taxes are going in the future. So what have we done? We've planned for long-term care, and we've planned for taxes as well. Now here's another situation. This is Betty, age 73. She has an IRA, checking, savings, some stocks, mutual funds. She's also concerned about long-term care, and she wants to avoid probate, and she doesn't have any long-term care, and she has a basic revocable trust. What might we do? We might move all that post-tax money into the trust, move the house into the trust, all of that's protected. Let's say she doesn't need the IRAs for income. We could reposition that $250,000. So now it's $480,000 of long-term care benefits or tax-free death benefits. So now we've protected against not only nursing home care with the Castle Trust, but also we've provided protection from home care and assisted living. So those are just two examples of ways that we can help putting all these pieces together for you. Now, we threw a lot of information at you. And so what you're going to do is you're going to have an opportunity to have a phone call with someone on my team to figure out if we can help you. And one of the things that we do is we help you get organized. It's kind of like a junk drawer. Everyone has that junk drawer where they have a lot of important stuff and maybe some unimportant stuff, like a chewed up apple. Like you don't need the chewed up apple. Sometimes we hold on to stuff that we don't necessarily need. But one of the benefits of working with us is we at the very least will get you organized. We'll help you figure out where you're at and figure out where you need to go with your planning. So the next step is to reach out to us and schedule that 15-minute strategy call where we figure out where you're at, figure out where you need to go, and figure out if we can help you. And then from there, the next step will be to set up a longer visit, a longer conversation, whether we do it face-to-face at one of our offices or we do it via Zoom. We have a very smooth and efficient virtual process where we can help clients throughout Michigan, actually throughout the country. We help clients throughout the country with our virtual process. And the whole process has been engineered to give you peace of mind, where again, we figure out what are your goals, figure out the best strategies to help you achieve those goals, and then pick the right tools. Too often there's other professionals who are trying to sell you on the tools, whether it's a trust, an annuity, or life insurance, and everything's backwards. We take the exact opposite approach, where first we figure out what are your goals, figure out the best strategies to help you achieve those goals, strategies from a financial, from a tax perspective, from a legal perspective. As a certified elder law attorney, we have some unique strategies and tools that we can help you to achieve those goals. So if you do want to set up that appointment, please make sure to click the link to schedule a short phone call, and then we'll get to know each other a little bit. And then from there, we'll schedule a longer visit, either face-to-face, via the phone, via Zoom, whichever is most convenient for you. And again, our whole process is engineered to give you peace of mind, to protect you from probate, protect you from the devastating costs of long-term care, put more money in your family's pocket than the IRS. So if that appeals to you, I look forward to continuing this conversation. This has been Chris Berry with Castle Wealth Group. Thank you so much. Take care.